Today we're going to talk about the difference between a basic policy coverage and enhanced policy coverage. And I'm going to pull up some information so we can kind of look at it and talk as we go. And then it'll be a very open forum. So I'll give kind of what the basic differences are between the two. Then I'm going to say what the practical differences is that I have like a little signature blurb that I'll drop down into an email whenever an agent or an agent's client reaches out. It's just three like major points among 25 that's out there. So, and then that may spark some ideas, mark some questions, and we can spend the majority of our time in dialogue. I will really need your help, Haley, because there may be some specific questions that maybe I've not run across before. So I might end up saying, let me find out, and then I can email the group back. So give me just a second, and I'm going to pull that up so we can share my screen. And you are going to see the same flyer that I shared last week. I just highlighted the two things that were pertinent to title theft, which is what we talked about last month. So this is going to be hopefully familiar to you. Let me make sure it's not too big. Okay. Go ahead and share my screen if you can.
Me?
So you can see the basic versus enhanced policy.
So you are not sharing your screen yet.
Okay, so it's probably something I got to click on here.
Yeah, so
Share
at the
screen.
bottom.
And this is the screen I want. I'll eventually get it.
There you go.
Okay, see me? All right. So let me get this out of the way. So at the heart of it, I just want to kind of pull back all the way to the basics. At the heart of title insurance is two things. For the owner, it is ensuring that you and only you have the rights to this policy so that nobody's grandchildren, no other entity can come up and say, no, we have rights to the property. Now we're going to challenge you and pull you into court through a very lengthy, expensive process. So that's how the title insurance was born. For the lender, it's kind of the same concept. For the lender's policy, we are just ensuring that you, lender, are number one on the list. So nobody else can try to take that property if your borrower defaults on the property. And anytime you get a loan, you will be required to pay for a loan policy. The owner's policy is a one-time thing. It lasts for as long as you own the property. And even if you die and pass it on to an heir, it keeps going. So it's a one-time premium that goes for your lifespan as long as you own the property and even if you deed it on. The loan policy, every time you get one, even if it's with the same bank, you will have to get a new policy because it's just on that specific product. So that's just kind of the different perspectives. We're just going to be talking about owner's policy, but I just wanted you to understand, you know, what those differences are. Sometimes the quotes or the CDs, the attorneys will put on there that owner's policy is optional because they can't tell you what to do with your property, but 99.9% of the times that attorney is really going to push it. Even if you just bought $15,000 worth of land, relatively small, you just don't know what could pop up, especially when dealing with family land. So just kind of keep that in mind. You've probably seen that 1,000 times. But today we're just going to be talking about the main differences for owners' policies between the basic and the enhanced. And this is a condensed, easier to read version of the comparisons, there is actually at the bottom of this page a hyperlink. When we send it to you in PDF, we'll resend it again this session. When you click on this last line for a complete list and detailed comparison, boy, it gives you like 2 pages of just black and white, cross your eyes type information. We tried to make this a little bit easier to see and read. So I'm going to scoot back up the top and let me see. So I'm not sure if they're on here, but I want to start out by saying in my email blurb, which I'm happy to share, or you're happy to forward my information to your clients if they start asking you about the difference in the two, because I certainly don't want you to get into a discussion that's really not your area of expertise. You already have 1,000 things on your plate that you're the liaison and trying to, explain. Just know my name, know my number, know my email, and feel free to pass it on. But the 3 very easy, practical things that I think every agent clicks with and understands is a basic policy has 0 coverage when it comes to permits. You pull up to a house or you're reading the information about the property and, oh, that's great. There's a bonus room. There's a garage that's been converted. There's an addition, yada, yada. So you do not get any permits coverage whatsoever on a basic policy. On an enhanced policy, you do. This is huge for a lot of reasons. The attorney's work that they do in the title search that's not in the scope of their work. They're not going to look at that. I don't even know if that's a required or expected part of y'all's work, but I do know that some of y'all do take that extra step. But it's just understand there's nobody to really officially go back and point to and say, I bought this property, now I can't do, or now I'm in a big, expensive loop to try to first correct the permit. Maybe the permit was never obtained. Maybe it was obtained but never closed out properly. Those are going to become factors when you or your client want to make any kind of revisions. Maybe you want to knock down a wall and do some sort of upgrade. Maybe you want to add on. Maybe you've even had a hazard insurance situation come up. Maybe a tree's fallen on that part. And you know how insurance companies can be. If they find any sort of loophole, it's possible that they may say, well, this permit wasn't closed out properly, so we're not going to do our work until that is done. So it's extremely important. I feel it's very practical because people are, doing a lot of things. And when you own your own home, you can be your own contractor. So that's a scary thought. The whole buyer beware, takes on a whole new meaning. But you have to own your home for a certain number of years. I worked for the city of Rock Hill for a little bit in the permits department. I don't really remember what that time period is, but I want to say it's like 2 or 3 years. You have to own the property for 2 or 3 years after you do that self work. I could be wrong, but that's kind of a situation there where you really would want a professional, an attorney, a counsel on your policy side, step in and try to really mitigate the loss, handle that situation, work with that city or that county to say, how can we resolve this? That's a major, I think, practical application for an enhanced policy versus a basic policy. You get nothing. Another one that is very applicable, really in the mountain areas, it's extremely applicable. But even in some of our outlying areas is access. So you obviously have to have access to your property. Well, in previous policies, access just meant one car. Well, that's not, you really need the length of 2 cars to truly say this is a passable and accessing property in and out. So that's kind of like a side benefit one. Another practical one is just in general, your policy coverage amount with an enhanced policy within the course of 5 years, that amount increases, your coverage increases by 150%. So that's significant when you think about inflation. You don't really know what type of issue is out there. So whatever your sales price is, it's going to go up by 150%, by the time you get to that 5th year. And when you're talking about property that you keep insurance for as long as you live, as well as when you pass it on, that's pretty significant, I think. The third thing is survey coverage. Very, very few people are getting surveys. Always recommend it. Maybe even do some CYA saying, here's some documentation where I highly recommended it, because you may change your mind. You may not want to do anything with the property now, but a year, 2, 5 years from now, maybe you want to build a pool in the backyard. Well, if you don't have a survey that tells you the easements that may or may not be there, the zoning, by the city or county, they may have some, zoning rights and easements back there, and you don't want to go pull, a $15,000 pool right on top of that. And if they need to use it, you gotta remove it. So without a survey, you're not going to know that. So obviously, you guys know to highly recommend that. But the reality is, some people don't have that money to pay up front, or for whatever reason, they're refusing to do that. Well, you're SOL with a basic policy. With an enhanced, you do get some coverage. You think of it like when you have a boundary survey. There's any sort of encroachments, maybe the HOA or maybe your neighbor. There's something that maybe a retaining wall. Maybe it's been there for 5 years, 7 years, however long you can remember. But somebody new moves in, and they have a survey, and they see, oh, it's over my property line, or the HOA gets a new, hyperactive, hypervigilant president that just wants to really clean house and whatever they're justifying, and brings this to your attention. With an enhanced policy, you can call them up and you can say, hey, here's the situation that's going on. I didn't get a survey, but I understand my enhanced policy has some survey coverage. Can you help me? That's where they're going to step in. Like I said, it's particularly helpful with boundary issues and adjacent properties, dealing with HOAs, that sort of thing. I do have to tell you, it likely will not help you with zoning. So in our state, zoning have 0 statute of limitations, meaning it doesn't, the city never, or county never, loses their right to enforce that, as opposed to your neighbor or an HOA. They only have, I think it's 7 years. I'm not an attorney, but I'm pretty sure that's what attorney and counsels have told me. They have 7 years to say, hey, this is not in compliance with our rules. I want to enforce removal of it. Well, the council is going to come back and say, well, here's when it went up. It's been beyond that time. You have no case. Or if it's close to that time, they can really talk much more intimidating and with much more authority and knowledge than you're just regular real estate attorney. They just typically don't deal with that sort of stuff. Whereas you're working with a national company. We deal with Fidelity, is the most of our work, and also First American. Both have been in service for over 200 years. So they are giants in the field. So they also have a lot of knowledge as well as experience. In risk management department, they are typically attorneys that are dealing with the whole East Coast. So not just our states, they've seen a whole lot of stuff. So they just got more savvy with how they can talk and things they can work with to resolve the situation that would be driving you insane. And if you did choose a local attorney, your cost would be astronomical through the roof. So within reason, they're going to make every effort to get that resolved. If they see that it's a really crazy wackadoodle thing and it's going to exceed the amount of your policy, even if it's the 150, in those rare instances, they'll just pay you out the policy amount. I've never heard of that being done. I've been in it for 20 years. I've worked directly with Stewart Title's regional risk management and claims department. Never heard of that happening. Just kind of wanted to put that out there. That's would be the very worst scenario, but 9 times out of 10, they're just reasonable attorneys that are knowledgeable and know how to speak the language to the opposing party to say, let's resolve this a better way. So those are the 3 or 4 very practical things that happen probably on a regular basis, more than you would think. We can kind of go down the list. One of the things that we mentioned last month with talking about title theft was forgery after the closing. So both policies will step in and help you resolve situations if there's a forgery that's discovered up to the closing. The basic policy stops with regards to forgery, anything that has happened after the closing. You now own the property and something has happened afterwards. Your basic policy has stopped at that point, because basic policy is just your double layer of what the attorneys have done. So their necks are on the line. They've signed and said this, and this needs to be cleared up. So attorneys make mistakes. Attorneys go out of business. Attorneys only keep their files 7 years. So if something pops up, you're 8, 9, 10, or whatever, you really can't go back to the attorney because they're not even going to have their files to prove anything. But at least your basic policy is going to help kind of look into that and redo whatever they need to do and go to court and resolve that sort of thing. But again, if it's after that transaction has occurred, you have to have an enhanced policy or they're not going to do squat to help you. And so that's where we, wanted to pull this in when we were talking about title theft. If it's a random thing, I can't figure out how they're targeting people because a lot of it's done online. They forge a deed pretending to be you, sign it off to themselves or whatever entity, and then they've got a cash buyer who doesn't have that level of protection from the lender or the seller, and off goes the sale of your property, and you don't know until you're trying to refinance or get an equity line or sell your home. So in that situation, God forbid, if you're one or your client has fallen into that situation, you want to ask, first of all, where's your owner's policy? And tell me it was with executive title, because we do enhanced 99.9% of the time, because that's a huge step. Otherwise, like I said, you're going to be looking through hundreds of attorneys hoping that the one you pick is experienced enough to handle and clear up something like that. But I just want to go through, is there any questions on those things or anything else practical that y'all can think of that might have come up?
I have a question. So you are the buyer's agent. The agent wants to have this enhanced policy through you guys, but the closing attorney goes, oh, well, we found a prior one and we want to use that. Do they absolutely have, like if my buyer says, no, we want this, they have to use that, is that correct? They can't say, oh no, we're using a different one.
Well, two things that you're mentioning. It's very beneficial to have a prior policy. So that is just giving the buyer credit In our market, it's typically like $100, maybe $200 or more. So that's good. There is absolutely nothing wrong with an attorney saying, I want to use this prior policy because it's to the client's best interest. True statement. What is untrue if that same attorney says, but I got it from ABC Title Company, I don't want to use executive title. If your buyer is saying, I want to use executive title, that is his or her legal right. So, and you can say, I'm educated on the products that are offered. My client, it's in their best interest to have an enhanced policy, and I want you to send it to executive title. Period. End of story. Some stubborn and not so friendly attorneys may then come back because they just want to win the fight or whatever. They may come back and just say, well, it's not good business to take from here. So now I'll have to do a full search, and that may or may not cost your client more. That's a pretty common fear tactic. It is not necessarily true, because if you think about it from their perspective, their publishing rates of what their searches are without a disclaimer. I've seen a lot of them. There's very rarely a disclaimer that says XYZ. You might, but it may be true. They very well may be outsourcing it to a third party who has charged them more, and they may just be passing along that fee. So that's fair. That also is in the client's best interest to get a full 30-year search. It's not true that they can't still use that policy. That policy is in their hand. They can still use it and give the borrower the reissue credit, even if they did a full 30 years. They can use that regardless. They just probably want to keep good relations with that title company because, and this is the reason, when they get a prior policy, that attorney does not have to search a full 30 years. They only have to search from the date of that policy. So it makes it cheaper on them. It makes it less riskier on them. So it's less work. So I get that's understandable. I get that. But when you have an educated agent, you have an educated buyer, and they're exercising their right, that attorney should be smart enough to say, your agent is bringing me this business. I need to nurture and respect that agent, respect that buyer's legal rights, and shut my mouth. So, if you're really kind of butting heads with an attorney over this, really question why. Because they can't have any affiliation, no financial relationship, nothing in North Carolina with a title company. So they're other than the items that I list there, they're just making it easier on themselves and trying to bully you into a situation when you're the one that's bringing them the funds. So kind of tuck that in the back of your mind if you run into that. Anything else? Any other questions before we go?
There are no questions in the chat as of yet.
Okay. So we'll just kind of go down this line here. Again, it's very subjective. Of the 24, 25 items, I just kind of pulled from, the underwriters and put them in here so that they just made more sense. It's still the same verbiage. So, if we have a question that comes up and maybe I don't understand more than one term, I will go back and ask the underwriter, but I did pull it over and just try to put it in a little bit better format for us to go through. So both of them are going to give you secure your rights to the property. All right. Someone else affecting that comes and records leases, or maybe pops up an unrecorded lease. You got a tenant in there. Maybe they didn't record it and you didn't find out, but I'm showing up to move into my new home and there's a squatter, or there's somebody there that has a legitimate lease, but it wasn't discovered because it wasn't recorded. Both policies are going to help you resolve that. Someone claims to have rights affecting your property, but it's through forgery or impersonation. Again, they're claiming existing rights to your property. So that's how this is different than the post-closing forgery situations. They're claiming a document that shows prior to your closing date, owns it, turns out to be forgery. You still got to back out and kind of fight and clear up that title before you can get anything done, before you can sell it, before you get an equity line, before you can get refinance on that property. Someone else has a recorded or unrecorded easement on the land. Just had a question yesterday. I think it came in from Jeff Lynch up at the lake. You might see this a lot, or maybe farmland. I can see that, but somebody's popping up saying, hey, I'm your neighbor and I have rights to cross your property to get to the lake. Excuse me? Didn't know this? Your attorney should have found this. Things like that are exactly why you have to have a licensed attorney do a full title search. There is literally a difference between the term title search, that's full blown, only an attorney can do that in conjunction with a closing, and a property report that we do. Property reports just kind of giving you the superficial information found online, judgments, but easements, things like that should have been found. Maybe it was missed. Maybe the attorney's out of business. Maybe the records are so old we can't pull up to see if it was their mistake or not. Both policies, their attorneys will come in, research it, make the determination, go through all those costs with the other parties, so your life isn't being disrupted in and out of court and freaking out with this document and that document. Your title's defective. I have actually seen this. Let me see which one. One of these I know I was involved in. Don't ask me how we resolved it, but it was a nightmare. Your title is defective. So something has happened that hasn't been cleared up. Maybe maybe an heir didn't sign off on a property. Now they're popping up saying they own some of it. Well, if they didn't have, if their signature wasn't obtained, that's a defect. Someone else fails to transfer. That's what that first one is saying. Same thing, just means electronically. Document upon your title is based invalid because it was not properly signed, sealed, or acknowledged. This one is a little more focused on basically notaries. Not so much now because the notary laws have changed and been updated, but previously notaries' acknowledgements had to be worded a very specific way. It didn't, now it just has to make sure that it's signed and dated with their expiration and says, so-and-so personally appeared before me. Previous to some changes, there was a whole lot of stuff that it needed to say, and some people had it and some people didn't. So you just basically got tied up in court to waste your time. The judges would still say, but you still own the property. Everybody signed it. Everybody knew what was going on. It's just this little technicality. So that's kind of where that item is coming from. Different story if, let's say, the property came out of an estate or a trust where there are documents that specify everyone that needs to sign or only this one person can sign. Again, that's onus on the attorney. So this is your second level of protection if the attorney misunderstood or is no longer in business, or it's so far back they just don't have their file anymore to look it up. So instead of you having to pay another separate attorney to do everything, both your basic and enhanced will dig into these items because it's in the past. It's happened before you acquired the property. Same thing here with the public records. Sometimes indexing gets a little wonky when you have hyphenated names or unusual names. Again, some abstractors that are employed or direct attorneys doing the searching just make a mistake. The last one is there's a defect, a judicial or administrative proceeding, again, going towards like an estate, or in South Carolina, if you default, the judge can, take the property back and assign it to somebody else, or probate. You're the administrator for this estate, and there's certain letters and certain processes that the probate office requires you to go through. Notice to creditors, for example. So if I pass away, even if I have a will, there's a whole list of things that have to go through probate. So even if the person died, 7 years ago, now you're trying to do something with the property. If they never opened a probate file, you're gonna have a couple of months delay. So honestly, that's where it's very helpful if you get a property report from us, because we will let you know if we see an estate file has been opened, especially if it's recently. We kind of give you that heads up. Hopefully the client has already told you about that. Some people just don't. All right. Now we're getting into the rest of the document. Is going to show you some, not all, but some of what I thought were the practical, relatable coverage that you'll get. Sorry, I don't know how to keep those from up. That you'll get with an enhanced policy. So you notice how they make a big point to say all of the above occurring after the date of the policy, when the transaction occurred. So now we're getting into permits. I thought that was so important, so I made sure I put it right here. You're unable to get a building permit. They're not going to give you a building permit if you didn't close out or you did something before. Your request number 2 right there. You're required to correct something. There's some sort of violation. An enhanced policy stepping in and doing everything right, what should have been done the first time. I don't know if anybody watches HGTV, but there's a guy I used to call Holmes. His last name is Holmes, Holmes, Holmes on Homes. He now has come back with a revamp where he's got his children in. So it's the same concept. He would come in and of course they would cherry pick the worst situations where poor homeowners have paid thousands of dollars. They got crap work done. So not only do they still have the same problems, in some situations they have worse. So Holmes would come in, evaluate, and do it right. That's what they're going to do with an enhanced policy. Okay, number 6 is something that we don't really talk about a lot, but I understand sometimes this is affecting more people like in the mountains or areas where there might be minerals in the soil, but mineral rights, to an extent, we already add to, it's an endorsement, we already added to all the policies. So to some extent, you're getting that, the lender is anyway. The owner, not so much. So let's, number 7 here says like you're got an improvement on your property and it gets damaged because the land has some sort of minerals or extraction that needs to be removed. And so company has the right to do that. They've accepted or reserved it in a description of the land found in the deed or a restrictive covenant, something of that nature. It doesn't happen often, but if it were to happen, an enhanced policy is going to step in and help cover the cost of actual damage. Like maybe, you added a porch and it just happened to get damaged as somebody was coming in, exercising their right, or maybe it was over the easement and whammo, here we go. And you got $10,000 worth of damage. They're going to step in and help out with that. Your number 8, your existing structure is damaged because of a right to maintain or use an easement affecting the land. I always think about this. The first thing that comes to my mind, maybe because I just mentioned Jeff and his lake issue yesterday, but Duke has rights to, Duke Power has rights to the lake and maintaining the water levels, and maybe they pumped into your expensive dock. Oh crap. That's gonna, help right here. Let's say maybe you did have a survey and you did build a pool and you're not in the easement. However, it was close enough that ding dong, came in and whoopsie, fell into the pool or, damaged it in some way. Your enhanced policy is going to go back and forth with them to help repair the costs that were done as a result of them exercising their rights. Does that make sense? Duke's plowing through the back of your yard and, oh, there goes your beautiful landscaping that you've spent quite a lot of money, building, or a koi pond, whatever. All right, number 9. It's relating to a survey issue. If you had a survey, you would have known. Your buyer decided not to get a survey. Number 9, you're forced to remove it. And remember what I said, if you know that it's something to do with zoning, that's going to be one of these exceptions that the policy's just probably not going to help you with. But let's say you have a beautiful retaining wall, or you have some sort of expensive privacy fence, and maybe even bought the property that way. They're going to step in and they're going to first look and make sure that it really does have to be removed. If it does, and they're within that time frame where they can sue you and force you to remove it, and you're actually losing value, you're losing money because of it, they're going to step in. They're going to step in and help resolve that situation as best they can. That's not to say that they're necessarily going to give you the money that's lost, but if the market value significantly deteriorates as a result, then that may be a payout situation. I personally have never heard of an example of that, so I can only take a guess on it. The number 10, we've got, another building, another permit related is you are forced to remove this gorgeous she shack in the back that's right on a zoning easement. The city or county have infinite rights to make you remove that, and for whatever reason they've now decided it needs to be removed. Well, zoning is probably not a good one because you're going to have to remove it, but let's say it's a setback or an HOA build that you've encroached in, because any portion was built without a permit. Okay, I'm sorry, I read that wrong. Let's say you built a building and you didn't have the foundation correct to support that size, and I don't know, somebody called you on it, or sometimes the what do you call them, the people that check permits, sometimes they'll do drive-bys, and if they see people working on roofs or working on the back, they'll pull it up real quick, type in the address and see, oh, permit wasn't of that. They'll come stop you. This wasn't residential, but I'm going to give you an example of this. I lived in Rock Hill at the time, and it was right when QT was just coming into town and building everywhere, and right off Celanese, there was a great big one. And I was working at the city at the time. And so they did, I forget exactly what it was, but it was something to do with underground tanks. It had to be built and permitted and approved a certain way before you put the asphalt over them. They didn't get it. And the inspector said, I don't care how much money, I'm not signing off on this permit because you closed it without me putting my eyes on it. So you're SOL. They were out thousands, I don't know how much, but they were out thousands of dollars. But the inspector has the right to do that because that inspector's name's on that. And if there was ever any sort of suit to come, that's the person. And so, yeah, he made him rip it all up, and here we go. So if we had a similar situation on a residential level, they would step in and try to keep that cost as little as possible or see what they could do. The last one I have in here had to do with access. I mentioned that at the beginning. I mean, it really could happen anywhere, but what first comes to thought is the mountains and farmland that's being sold off or to like individuals, not necessarily subdivisions, because developers know to make it, at least 2 car lengths wide and passable. But a lot of property that is in the mountains still have very narrow, barely a single car. So that's not considered in an enhanced policy. That's not considered true reasonable access. True reasonable access, you got to have 2 cars being able to reasonably and safely pass each other. So if you buy a piece of property and it was, I don't know, several acres, you didn't walk it, you didn't work something out with the seller to make this teensy tiny road this big, or maybe you weren't aware of it and you discovered it after the fact, your enhanced policy, you can reach out to them and say, hey, I need help just navigating how to make this wider. What can I do? And they're really going to dig and search and see if they can pull anybody in to help and make that legit, or pay for it to the extent whatever's reasonable. I don't know what the costs would be, but I did have one situation come up, and I really don't remember where it was at. If it was in the Carolinas, well, it had to have been in the Carolinas, but I really don't remember where it was at. But guy bought a piece of property. He saw it was one lane, and he was willing to put the cost in to clear the forest to make their rights. But he, ran across an issue with neighbors wanting to fight him, and it take up a lot of his time and money. So when he reached out to me, I said, well, I think you should reach out to the company. You have an enhanced policy. They're going to have ideas and rights, and if nothing else, they're going to be that knowledgeable voice to help you get the job done. We all kind of know when somebody gets a letter from an attorney, they tend to respond more quickly than a letter from you or a call from you. So those are just the ones that I have listed here. Does anybody have any question over any of that or need some clarity?
So Allie, I'm not sure if you covered Judy's question already. Someone came in my office, but she asked if they cover the cost to get a variance.
Likely, like if it's after the fact, because it wouldn't help you before the fact. So if you go into something, same with the survey, you get a survey, but you see there's an issue, you haven't bought the property yet, so that's your decision, your cost, both of those situations. But if it's after the fact, very likely I would say very likely. I'm imagining I've bought the property. I did not get a survey, so I'm unaware that an existing structure is non-compliant, so, okay, can I get a variance? Can I make it legit? Because eventually I'm going to sell the property. I know I'm going to do that. So I would reach out in that instance. You have nothing to lose to call and say, this is my specific information. Actually, you usually have to email, submit it in writing in some form, email or handwritten. This is my specific situation. If there's a cost to it, they may or may not cover it, but I would think there would, because I don't know what the cost of it would be. I honestly just assumed there was no cost, that it was more I got to show up, I got to find the meeting time and plead my case. They would, I believe, definitely help you with that. Because they are the experts, they are familiar with the law and how things read, so they can pull up that specific county or city and look and identify first what is in violation and be able to talk the lingo. So I would venture a guess and say very likely.
Thank you, Allie.
You're welcome.
So Judy had a follow-up. So the building/structure would have to already be there.
What do you mean?
In regards to the cost variance. Oh, she said the building would have to already be there when they purchased.
Oh, talking about the variance.
Mm-hmm.
Yes, because you are looking at a property, your buyer is looking at property and buying it as is, and whether you're choosing to get, or maybe you weren't given information about, is it in compliance or not with, various organizations. That's your choice. So a policy of any sorts is just saying, oh, you weren't given the choice, or you were given bad information, that sort of thing. We're going to help rectify it. If after the fact, now you're wanting to intentionally put something on, no, because it wasn't present at the time that you bought the insurance.
Got it.
Yeah, doesn't hurt to ask, but I'm 99% sure they would say no, but you never know. Sometimes you get nice people who are like, oh yeah, sure, let me help you with that, even though it's not technically, required, but.
Joel also had a question. I believe that's Joel out of Asheville. Hey, Joel. Anyways, he said,
yay, mountain person.
Yay, yeah, we have.
Let us know about that access issue.
Yeah, Mitchell's on here too from Asheville. Anyways, so Joel asked, years ago, listing agents would be asked if there is a prior title policy by the buyer's attorney. Why aren't we asked that anymore?
I'm surprised that they're not asked anymore, but I'm not surprised. So going back, it is a very good thing for you to already do, especially if you're representing the buyer, to ask the seller. But we all know people do not keep records like they used to. So very likely attorneys were like, nobody's keeping records, 2 years ago, much less 15 years ago. So then they started doing what I tried to get ahead of and would love your support on. I'm an attorney and I've received a contract from an agent. The first thing I'm gonna do is I'm gonna send out a mass email or go to my buddies if investors has got a big stronghold up there, but I'm going to go to as many title companies as I can and see if they have a prior policy. I have Fidelity and First American, so I have access to their databases. Even if I didn't do the work, I can get a copy of the work. And so that became more realistic for them to go that route than to chase or wait for this, because they need that first to start the search. They want to exhaust every method possible. And that's where I would love y'all's help. When you email the contract or drop it off, whichever the case is, to the closing attorney, if you copy us at orders@charlottetitle.com, that gives us the opportunity to stop what we're doing, check our databases and see if we have it, and give it to them, because that is the golden ticket. It is a first come, first serve situation, because again, that attorney wants to reduce the risk and the amount of time and money searching the property. So if I've been copied, I've found it, I am shooting it to that attorney as fast as I possibly can with my contact information on it and saying, please send it back to me. They're going to do that, because that's good business sense. And that's kind of where we were talking back with Sue at the beginning. Yes, I agree with you, attorney. If you've gotten a policy that has been helpful to you from a title company, it's only good business to send it back to them. But you got to keep the bigger picture in mind. That title company is not providing your bread and butter. Those agents are. So to me, an attorney, it's very suspicious and disrespectful when an attorney does not immediately acknowledge you are the one agent who has brought me this money, not the title company. It's nice to get it from the title company, so I don't have to do as much work and I don't have to take on as much risk. But at the end of the day, I'm a smarter business person by acknowledging who really brings it in. But prior policies are really, really invaluable. It's a very good thing. Plus, the bonus is your buyer gets a discount, as long as it's within 15 years.
Alrighty, and that was the last question in the chat. Does anyone have any other questions for Allie about basic versus enhanced policies or anything title related? Allie, I have a question. What are we doing next month?
Good question. I would love topics. We're gonna have like a lunch and learn, so hopefully I'll hear something from there. But I had all my topics down. I thought about. I feel like I had one idea that I hadn't checked into yet. I think it had to do with like estates. I'm seeing, I hate to phrase it this way, but there's a product that I'm going to pitch to Karush that I think is very helpful to agents who want to tap into farming. You know, they want to, for whatever reason, they want to identify people who are empty nesters and target them a mailing, or they want to identify property that is in default. And they want to, you know, send mailings to them. Well, estates are a little bit tricky. In same concept is farmland, or I mean, family land is a bit tricky, because you have to have the same people sign in different ways to make it fully legit. So my thoughts were maybe it would be interesting to have an attorney join and bounce ideas back and forth off them, specifically to estate files and how long does it take, what's the process that it has to go through, and maybe talk about those. So that was the only other thing that I'd come up with. But if anybody has any ideas, or you see what's, you know, more impactful to our group, please email me or Haley and let me know.
Alrighty, so Allie, I'll send you our guest list from today if you want to send them this breakdown again. And thank you everyone for joining the third installment of Allie McCormick's Title Talk.
Just a reminder, they are being recorded and we are adding them to my website. So I'll put in the website again. I think I saw last week or the week before where Jason had put at the top of the menu, it says resources, and now it says video library. So when you go down so far, you can see them building up. So if you later on down, you go, oh, I know it was mentioned in that, title theft or basic versus enhanced. It's very easy to find, and you can point clients to it or share it. Well, I don't think you can share it, but there's also PDFs where you can share this information too.
And also, Millie and Myrna, Allie is hosting a lunch and learn next Wednesday at 11:30 in the South Park office if y'all want to drop by. Yeah. Okay. Well, that's it, everyone. Happy birthday, Ashlyn. And we'll see you next fourth Tuesday in April.
Yep. Bye. Thank you, guys.